Thank you, Mr. Chair. Mr. Rosenzweig, in your opinion, does the House Judiciary Committee have a legal basis for seeking disclosure on a confidential basis of the grand jury materials that are subject to Rule 60?
I believe it does. I believe that would be strengthened if impeachment proceedings were to begin, but I believe that the McGeever case is distinguishable on the grounds of this committee's superior legislative interests.
Now, separate and apart from the question of impeachment proceedings, the chairman has previously announced that this committee will pursue an inquiry on 3 different subjects. 1, obstruction of justice. 2, abuse of power from the administration. 3, the culture of corruption that could possibly exist at 1600 Pennsylvania Avenue. Do those 3 independent subjects provide a basis for which we should have a firm foundation to seek this grand jury material?
In my judgment, yes. I would say that all of those are suitable and cautious preliminary steps in anticipation of the possibility of considering impeachment. And therefore, this committee has not only a legitimate oversight interest, but one of the highest constitutional moment.
Thank you. Professor Shaw, does executive privilege cover communications the president has with private citizens who do not work at the White House?
I don't believe so, no, Congressman.
Does anyone on the panel disagree with that position?
Well, I'm not too sure how I'd answer that. In my testimony, I get into the question of attorneys, private attorneys, and that's a difficult issue that I discuss in the testimony. A court could very well create new law that this committee would not welcome if you push that issue.
Okay, Professor Turley, would the assertion of executive privilege cover communications between the president and Corey Lewandowski, who is not an attorney?
No, I think that would be a disclosure to a third party. Although, as I mentioned in my testimony, when it comes to waivers to third parties, the courts have been somewhat restricted in how far they'll allow that waiver to go. The SB case that was referred recently, the court said quite clearly they will not, quote, lightly infer a waiver when it comes to executive privilege.
Right. Roger Stone is not an attorney, correct?
I have no idea, fortunately.
Okay, we can stipulate that he's not. So I would assume that executive privilege does not blanketly cover communications with Roger Stone. Is Donald Trump Jr. an attorney?
Once again, I have no knowledge of their backgrounds.
We can stipulate that he's not. I would assume that a blanket assertion of executive privilege does not apply with any degree of reasonable force to Donald Trump Jr. Is Paul Manafort an attorney?
Once again, I don't know.
Okay, let's stipulate that he's not. I would assume that the assertion of executive privilege does not, in a blanket fashion, cover communications with Paul Manafort. Chris Christie is no longer a practicing attorney. Is that correct?
Once again, I have no idea what his practice is.
Okay, yeah, I would assume that the assertion of executive privilege does not apply in a blanket fashion to him either. Now, Professor Shaw, in the context of this question of waiver, it does appear that several White House employees talked to Bob Mueller and his investigators in the context of the preparation of the Mueller report without the administration asserting executive privilege. Is that right?
I believe that's right, yes.
And so Hope Hicks talked to the Mueller investigators without the assertion of executive privilege, correct?
That's correct.
And Sarah Sanders talked to the Mueller investigators without the assertion of executive privilege. Is that correct?
That's correct.
And I even think that Don McGahn, the White House counsel, talked to the Mueller investigators without the assertion of executive privilege. Is that correct?
Yes, also correct.
And so what impact, if any, does the fact that the administration did not see fit to assert executive privilege in the context of an incredibly public investigation that the president tweets about every other day, but failed to assert executive privilege, and now, after the fact, want to put forth this blanket assertion?
You know, again, I think it's a difficult question. I think the argument would be that to choose not to assert executive privilege in the context of an investigator inside the executive branch, which of course Special Counsel Mueller was inside the Department of Justice, is different and doesn't necessarily waive the opportunity to, at a later date, assert the executive privilege as against, say, Congress. As I said, I am not predicting that the White House would absolutely prevail in that argument, but I do think that it's a close legal question and that it is not at least evident that by failing to object at this earlier juncture that the White House has for all time necessarily waived privilege as to all the contents of those communications when a body like this committee is seeking them.
Okay, 17 different intelligence agencies concluded that Russia attacked our democracy as part of an effort to try and artificially place someone at 1600 Pennsylvania Avenue. Does Congress have a strong public interest in getting a full understanding of what happened, how it happened, and how we can figure out how to prevent that from happening again?
I would say absolutely, an incredibly strong interest, yes.
Thank you. I yield back.